much. Thank you.
Secretary.
SB 1407, the motion is due pass to appropriations. Jones Sawyer?
Aye.
Jones Sawyer, aye. Melendez? No. Melendez, no. Lackey? No. Lackey, no. Lopez? Lowe? Lowe, aye. Quirk?
Aye.
Quirk, aye. Santiago?
On call, we need one more.
Thank you, Mr. Chair. Thank you.
Thank you. Mr. Manning, thank you for waiting patiently. You have items 7 and 10.
Yes, Senate Bill 1016 followed by Senate Bill 1129. Can we go in that order?
Yes.
Thank you, Mr. Chair and members. Senate Bill 1016 will extend the sunset date of California's determinate sentencing statutes until January 1st, 2022. It will maintain judicial discretion in California's tiered sentencing system. In 2007, the U.S. Supreme Court ruled in the Cunningham decision that portions of California's determinate sentencing statutes violated the Sixth Amendment of the Constitution. The legislature responded to this ruling by passing Senate Bill 40, authored by Senator Romero, which removed the statutory requirements that judge use the middle term as the presumptive sentencing term and provided the courts with the discretion to sentence in the best interest of justice. Many of the opposition arguments presented in the initial vetting of SB 40 have never materialized almost a decade later. This can be seen in the Department of Corrections and Rehabilitation's upper term sentencing reports, which show that in the years since SB 40 has been in place, judges have only sentenced defendants to the upper term 16% of the time, opting for the middle or lower term in 84% of sentencing decisions. The sunset date for the determinate sentencing provisions in this bill have been extended 4 times through 4 different bills approved by this committee. The legislative fixes put in place under SB 40 will sunset on January 1st, 2017, and if the sunset date is not extended, California's determinate sentencing scheme will once again become unconstitutional. I ask that you join me in protecting judicial discretion within the parameters of the determinate sentencing law and ensure California's sentencing statutes remain constitutional by voting aye on SB 1016. And with that, Mr. Chair, have some witnesses in support. Thank you.
Thank you. Two witnesses, 2 minutes.
Mr. Chairman, member Dan Filizzato on behalf of the Los Angeles County District Attorney's Office in support. Our office has sponsored the 4 previous versions. We drafted the initial Cunningham fix SB 40 and sponsored the next 3 extensions. Since the enactment of SB 40, the number of upper term sentences has actually gone down in the state of California, which is what we expected. If you look at the statistics at CDCR, they show the upper term sentences have gone down since the enactment of realignment, and now with CDCR only holding basically the serious and violent offenders, the number of upper term sentences in CDCR has increased because they are holding the worst of the worst. So you expect that they would get the most lengthy sentences. However, when you still look at sentencing overall and look at the number of 1170H felons in our county jail, there still is a decrease in the number of upper term sentences today than prior to the enactment of the Cunningham statute. This is exactly what we expected. This is the most cost-effective way of dealing with the Supreme Court's decision in Cunningham. They gave the state of California basically 2 options. This is one of them. We continue to sit down and are willing to talk with any groups that wish to discuss this. We've never been approached by anybody since the enactment of SB 40. We think that this is the most logical and cost-effective way to ensure that California's laws remain constitutional. We ask for your aye vote.
Thank you.
Mr. Chair, members, Marty Veronica on behalf of the California District Attorneys Association. We're proud to be the sponsor this year of Senator Bonning's bill to maintain the constitutionality of our determinate sentencing scheme. It's interesting to note that when the Supreme Court in 2007 rendered the Cunningham decision, that it gave California the direction gave California an approach to fix what they understood would be a major issue by such a finding that the system currently adopted by California would be unconstitutional. And Senate Bill, as indicated, Senate Bill 40 by Senator Romero eliminated that presumptive middle term, and instead, where that statute provides for 3 possible terms, the choice lies within the sound discretion of the trial court. This fix has been extended 4 times, the last time by Senate Bill 463 by Senator Pavley in 2013. I would just note a little bit of history. That bill went through with unanimous support, including from 3 members of this committee who were here in 2013. This approach has worked. It has not increased the undue imposition of the upper term and maintains the constitutionality of California's determinate sentencing scheme. We urge your aye vote. Thank you.
Thank you. Witnesses in support?
Laura Tenney, San Diego County District Attorney's Office, in support.
Thank you.
Asha Harris on behalf of the California State Sheriff's Association, in support.
Thank you. Okay. Witnesses in opposition? Oh.
Good morning, Mr. Chair, members. Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice. We have an opposed unless amended position. I'm not sure where to start, but let me clarify a few things. The California Attorneys for Criminal Justice, the statewide association of criminal defense attorneys, we were involved in the negotiations on SB 40 back in 2007. I was involved in that. Let me clarify a few things. One is, and I have in my hand the numbers from CDCR. One thing that we asked for 2007 was to track the number and percentage of upper terms issued in California and whether that was going to go up. That was our prediction, and notwithstanding what was presented earlier, the numbers that I have in my hand, not great at math, but I do have a calculator, that it's gone up from what was about 15% of all incoming state prisoners with an upper term. For the most recent numbers, now up to 21.5%. And it's been consistently going up at about a 1% clip over this time period. So we expected to hit about a quarter of all incoming state prisoners to have an upper term. So while we have fewer prisoners in our prisons, they're sitting there for a longer period. So that's number one. Number two, we actually have had discussions with the proponents of this bill and the sponsors, in fact, just a few weeks ago, including the prior witness. So maybe that was just a miscommunication to talk about how to reform sentencing. Let me just point out on the policy a couple of things. One is what we struggled with in 2007 is that our sentencing scheme was invalidated because judges were able to impose the upper term without giving the defendant an opportunity to defend him or herself against alleged facts, never put in front of a jury. SB 40 still did not give defendants the right to defend themselves in front of a jury around aggravating facts. It simply gave the judge the right to hand out the sentence upper, mid, or low term, and here's the problem with that. Technically, they're not supposed to rely on any facts. It is a game of semantics, and frankly, it's just misleading. We all know that judges rely on facts to give the upper term. They just can't say it. In fact, if they said it on the record that they relied on a fact that did not come out in trial, it would be unconstitutional. But the reality is that's what they're doing. And in fact, the factors that are considered, here's the semantics, are just facts. So what we have here is exactly what was trying to be avoided when Governor Brown in '79 adopted determinate sentencing, which is we have an arbitrary system. Okay, he adopted determinate sentencing to try to prevent one judge in one county or in one department from imposing a longer sentence on certain individuals and not on others. And he wanted some consistency throughout counties and throughout states. So you presume the middle term for everyone. And if there are additional facts, you give the upper term. That's what we had in '79. The problem was we didn't put those facts in front of a jury. Now we've gone the opposite direction with the results that I just described, which is we allow every judge to decide for him or herself which sentence to hand out without any consistency throughout the state. That is completely contrary to what was adopted in 79. And at that time, Governor Brown said we need to fight arbitrary sentences. We need to know definitively that there's consistency throughout the state. So while we support some judicial discretion, and in fact our alternative, which will be up here in a couple of weeks, still preserves judicial discretion, the only thing that needs to be changed, which is in our alternative bill, is that when there's an aggravating fact that a judge is going to consider, it must first be vetted by a jury, because juries are the ones to determine whether a fact is actually true beyond a reasonable doubt, not judges. That's just the role. Everyone understands that. It's a fundamental pillar of our judicial system. So we've allowed this current law to go forward for a number of years. We've seen the numbers, and I can tell you from the ground, the attorneys are just, it boggles their mind that judges can impose a sentence and they can't fight back. Even though they know deep down there are certain facts that probably aren't true, the judges are relying on, they have no basis to challenge it. Thank you for the time, and also we do respect why the author has to bring this bill forward as a backstop in the event that our alternative bill is not signed. So we do understand that.
Right. Thank you. Are there any other witnesses in opposition? Any members with Mr. Quirk?
So are you advising me not to vote for this and then to vote for 1202, or are you saying vote for this and then vote for 1202 when it comes up?
In an ideal world, we believe SB 1202 should be the law. Mm-hmm. We understand why the authors brought this forward, although it was presented a little bit differently, but as a backstop in the event that SB 1202 doesn't become law, then we have the same situation we had in 2007 where we don't know what the law is. So I prefer we go with SB 1202. I understand there has to be a backstop in the event that it's not signed. So, but I think as of today where we're at and based on the presentation, I would ask you not to vote for this bill today, and let's go with SB 1202. And then if we need to put in some conditional language, or they're joined or something, we'll figure, or we have some other bill as a backstop, we figure that out. But right now, current law is just not working. And frankly, I'm exhausted with the argument that it takes too much time to handle cases the right way. And that's what I keep hearing about the problem with our bill, is it just takes too much time. And I'm exhausted with that argument. So,
all right, well, given...
I respect you either way.
All right, well, I'll be laying off today.
Thank you.
Are there any other comments or... Are there any other questions? And I'll second it. Mr. Monty.
Thank you, Mr. Chair. Let me address some of the issues that were raised as part of my close. I would just answer Assemblymember Quirk's question that was posed to the opponent a little differently. I would urge your aye vote today to protect the state of California from being in compliance with a U.S. Supreme Court decision and also a decision of the California Supreme Court that found our current sentencing scheme to be constitutional. If this bill is defeated and the other bill, SB 1202, is defeated or vetoed, we put all of California at risk. We put sentencing at risk. That is not protecting the public safety of the state of California. I'm actually supporting the bill that was referred to, SB 1202. These are not mutually exclusive. This bill protects the state of California from being out of compliance with a finding of the U.S. Supreme Court in Cunningham. Our adaptation to Cunningham has been upheld by the California Supreme Court. So to vote against this bill today is saying we're just going to go back out of compliance with the Constitution and see if something else comes along that meets constitutional muster. I would also just respond to the opponent's statistics. As was alluded to by the representative of the District Attorney's Association, Mr. Felizardo, there is an uptick in the higher-end sentencing of inmates in state prison, in large measure because of realignment and perhaps because of Prop 47, that the people ending up in state prison today are the worst of the worst and have been sentenced to the higher end based on criminal record and commission of felonies where they were found guilty by a jury. It still represents a small percent of the sentencing that's being recorded, whether at the entry of prison or the real statistic that should be looked at, the one that I cited, is the statistic of all sentencing in California, not just looking at those coming into state prison. Our realignment is trying to keep the lower end offenders out of state prison and moving them into drug treatment, rehabilitation, etc. But, Mr. Chair, I appreciate the robust conversation and glad to answer any further questions, but I would respectfully urge an aye vote today on SB 1016. Thank you.
Mr. Clerk.
My concern with passing both bills is then we're just giving the governor a chance to make the decision instead of the legislature. That's my concern.
That's based on an assumption that the other bill makes it to the governor's desk. I don't know if that's a fair assumption, but I respect your perspective.
All right. Thank you.
All right. Thank you. As chair, I'm going to recommend that we move forward. I appreciate the opponents. I am too frustrated at this discussion about the judicial system, and when it comes to justice, that is just taking too long, and we're trying to microwave ourselves to justice. That's not justice. That's just convenience for a certain group. But I also believe we should have a backstop, and we need to work vigorously, and I'm going to support SB 1202 so that we can get that not only through this body and onto the governor's desk, but we work real hard to get the governor to sign what I call the updated, amended, or better bill and the better way to go, and so that we can resolve this problem. So recommend an aye vote, and
SB 1016, the motion is due past your appropriations. Jones Sawyer?
Aye.
Jones Sawyer, aye. Melendez? Melendez, aye. Lackey? Lackey, aye. Lopez? Lowe? Lowe, aye. Quirk? Santiago?
it passes. Thank you, Mr. Monty. Item number 10. SB 1129.
Thank you, Mr. Chair.
Yes, begin.
Continue. Senate Bill 1129 will repeal California's overly punitive misdemeanor prostitution statutes, which needlessly incarcerate victims of human trafficking by requiring a mandatory minimum jail sentence for repeat prostitution offenses. California's current misdemeanor crime provisions for prostitution require, upon a second offense, a defendant must serve a minimum of 45 days in county jail and a minimum of 90 days for all subsequent convictions. These provisions also explicitly prohibit a judge from tailoring an alternative punishment that may better address the root causes of the offense. Research has time and again shown that mandatory minimum sentences are not an effective deterrent and do not prevent recidivism. Mandated jail times not only tie the hands of the courts in using judicial discretion, they also create a disincentive for victims of human trafficking and those engaging in survival prostitution to participate in probation or treatment programs, as the defendant will receive jail time regardless of their participation. Mandatory minimums for prostitution are an expensive and highly flawed policy that should not be forced upon the victims of human trafficking, who are often forced into commercial sex trade as minors and subjugated to a revolving door to prison. Let me be clear, however, this bill does not allow those who break the law to walk free. If a person is arrested and convicted of prostitution, they will still face a penalty for breaking the law, but the severity of that penalty will be determined at the discretion of a judge and not by an inflexible, mandated sentences that are crowding our county jails and not leading to rehabilitation. I ask that you join me in allowing the courts to prescribe the appropriate sentence for these misdemeanor crimes, these punitive sentences by voting aye on SB 1129. And I have some witnesses in support.
Okay, before your witnesses, I would like to go ahead and approve the consent calendar, just a little bit of housekeeping. It got a little hot in here, so I forgot to do the consent calendar. SB 1127, Hancock, Commission on Correctional Peace Officer Standards and Training, Internet website. SB 1221, Hertzberg, Firefighters Interaction with Persons with Mental Disabilities. SB 1330, Galgiani, Missing Persons. And SB 1474, the Public Safety Omnibus Bill. Is there a motion? It's the consent calendar. I'll move it. Is there a second?
The consent calendar, Jones Sawyer.
Aye.
Jones Sawyer, aye. Melendez. Melendez, aye. Lackey. Lackey, aye. Lopez. Lowe. Lowe, aye. Quirk. Santiago.
Consent calendar is adopted. Sir, you may begin now.
Thank you, Mr. Chairman. And distinguished members, my name is Arthur Bowie on behalf of the California Public Defenders Association, who is sponsoring this bit of legislation. Just to add some comments to the members' opening remarks. We spend a lot of time in the public defender's offices working with other justice partners in establishing courts to deal with commercially exploited, sexually exploited children. We have one such court here in Sacramento County. There's other courts in Alameda, Los Angeles, and other counties are looking toward that. We know so much more about what causes young women especially to get involved in prostitution. And we're working diligently to try to deal with these issues in a more holistic approach rather than towards incarceration, at least at the juvenile delinquency level. That theme, that model is spurred the adult court to look at what can they do, because they know that the young women that they're working with in adult court, these prostitution cases, are kids that are coming out of the juvenile delinquency system, kids that are coming out of the foster care system, kids that are coming out of the just out of the neighborhoods that aren't coming to the attention of the justice system at an earlier age, and they're struggling trying to figure out what to do. They realize and recognize that most of these adult women are just as victimized as children that we're trying to address right here, right now, with legislation that's going through our legislature right now to address sexual exploitation. So we're simply asking that we take a pause and bring adult sentencing in this area to where we are with minors. To say, look, let's take a look, not necessarily looking to lock folks up, but to provide them with the services that they need so they don't have to continue to be involved in this particular type of lifestyle. As the member pointed out, there's nothing that changes the court's ability to incarcerate or punish or hold responsible any person that's involved in any of these behaviors. But we just ask that you give the court that discretion. And also it opens up the opportunities for adult criminal courts to work with victims of commercial sexual exploitation in a different way, in a more productive way, in hopes that we don't have to further incarcerate them going forward. Thank you.
Thank you.
Maya Ingram with the ACLU of California. We support SB 1129 because it aligns these offenses with California's general movement towards eliminating mandatory minimums. Rigid sentencing mandates have contributed significantly to California's prison and jail overcrowding. This legislation would allow evidence-based practices to be used by the courts to reduce recidivism and further promote rehabilitation. As my colleagues have noted, prostitution is a unique offense where the perpetrator can be both the victim and the offender, and many individuals who engage in prostitution have been forced or coerced into commercial sex acts. By eliminating mandatory incarceration for these individuals, we will further promote their rehabilitation and reduce recidivism. Thank you.
Thank you. No, okay. Any witnesses in support?
Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice in support of the bill.
Thank you. Witnesses in opposition?
Marty Varenik on behalf of the California District Attorneys Association. Interesting juxtaposition, Senator Monning's bill we were the sponsor of, and now I regretfully have to oppose this measure, which would eliminate that mandatory sanction for persons convicted of prostitution more than once. In addition, the bill would eliminate the court's ability to suspend a person's driver's license if the offense was committed in a vehicle and in close proximity to a residential neighborhood. With as much emphasis as the legislature has put on recently on combating human trafficking, we believe this is the wrong approach. By eliminating these additional sanctions for those convicted of commercial sex on many occasions, I think that this does little to crack down on the illegal sex trade here in California. The additional license suspension also focused on a particular aspect of that illegal sex trade. Street prostitution most often involves the Johns in cars picking up the prostitutes and driving to residential neighborhoods in an effort to avoid law enforcement. The license sanction was targeted to stop that behavior. For these reasons and others, as stated in our letter, we remain opposed to this measure. Thank you.
Thank you. Any other witnesses in opposition? Members, are there any questions?
Thank you, Mr. Chairman. Mr. Monning, here's the issue I have with this bill is we just had a bill by Assemblymember Gonzalez, AB 1708, which, you know, as one of your witnesses mentioned, we have been trying to crack down on the issues associated with human trafficking. And this bill, so the 1708 bill would be to crack down on the Johns, but this bill eases the sentencing. So it's in direct conflict.
Well,
right?
I think there's a way to distinguish the two. My understanding is that the motivation of Assemblymember Gonzalez is to give law enforcement and sentencing more tools against Johns.
Right.
The vast majority of those charged with prostitution are the sellers, and the vast majority of those are women. This bill does not eliminate sentencing for those women prostitutes who are found guilty of prostitution. It simply says the court will not automatically impose a 45-day sentence upon a second conviction or a 90-day sentence upon a third conviction. The judge may determine to do that. The judge may determine that that is an appropriate punishment or sentence for that female prostitute. But this removes that mandatory sentence.
But I'm not concerned about the female prostitutes as much as I'm concerned about the Johns who are pimping them.
That's fine, and I understand that distinction. I would urge you to look at this bill as giving a court more discretion in looking at women victims of prostitution trade who are put into that circumstance usually due to a series of very tough life circumstances,
Sure.
Often in a trafficking context, but not always, but always with probably a pretty horrific life story. This gives the court the power to direct those women to treatment programs, to counseling programs, and not necessarily to an crowded jail. In the committee's analysis, it recognizes jail overcrowding in 13 counties. Are we serving society by putting a woman prostitute convicted of a second offense or a third, 45 days, 90 days in overcrowded county jails? Or do we do better giving the court the discretion to determine other pathways?
Thank you, Senator Monning. I appreciate your clarification and would agree with you. I'm trying to understand why there wasn't a separation within your bill that would specifically address the prostitutes themselves and not include the Johns in this legislation.
Well, the Johns are also subject to sentencing at the discretion of the court, and a judge, upon recidivism of a male John, is free to impose whatever sentence within the parameters of the sentencing. It wouldn't be mandatory. What we do know, though, from the data, the vast majority of Johns, after a first arrest, the social embarrassment of that, the family embarrassment, it's usually the last offense. Female prostitutes, on the other hand, it's commercial survival. They're not pursuing whatever a John may be pursuing. They're pursuing payment and survival. So that's the distinction. Thanks.
Mr. Lackey.
Yeah, my concerns are similar to my colleague from Lake Elsinore. You know, I think that we can all agree that prostitution is certainly a problematic public toxin that is very complicated. But my biggest concern is this vehicle provision, because I think that really is targeted towards the Johns. And I think that Johns are clearly the ones who create the market for this particular problem. And I hear the reference in the synonymous relationship between human trafficking and prostitution. Although there may be some similarities, I think that there's a clear distinction that needs to be made, that they are different. But the fact remains that I believe that this vehicle provision holds Johns less accountable for their engagement. And they are the ones driving this problem, no pun intended. And so that is really why I have strong objection to this, because I think it softens accountability for Johns, and they are the biggest drivers of this problem.
I appreciate that. Again, just in response, the vast majority of charges for prostitution are leveled against the seller. The vast, vast majority. Those are the women most likely to be held under current law to mandatory 45 days, 90 days for second, third offense. The data does not show that the power of the court to suspend the license of a John has reduced the conduct of the Johns. The data rather shows after a single arrest, a John is not likely to recidivate. So you have different social motivations of what a John is pursuing to purchase and what a female prostitute, the vast majority, out of necessity, are selling themselves on the street for survival. The overlap, just to comment on the human trafficking, I absolutely acknowledge not all prostitutes are being human trafficked, but there is an overlap. There are a number of female prostitutes who are under the control and supervision of what are most commonly called pimps, which can be part of broader criminal networks where they are not exercising their free will. They are operating under intimidation, threat of violence, etc. And that does fall, in my view, under the broader umbrella of human trafficking. It doesn't necessarily mean they're being brought from another country. It can be in the neighborhood under the control of a criminal syndicate where that woman fears violence if she doesn't perform as expected.
Thank you, Mr. Monty.
Thank you.
And are there any other questions? And can I take that as your close?
That is, I would respectfully ask for your aye vote. Thank you, Mr. Chair. Appreciate your indulgence.
And I'm just going to quickly say I am going to recommend an aye vote because, mainly because, and this is not being facetious or in pun, that the judges will drive this, and that's what we really need to happen, to look at things case by case and come up with some ways to help individuals that have been trafficked in this hideous crime operation. So I recommend an aye vote.
Thank you.
SB 1129, the motion is due pass. Jones Sawyer.
Aye.
Jones Sawyer, aye. Melendez. Melendez, no. Lackey. Lackey, no. Lopez. Lopez, aye. Lowe. Quirk. Santiago.
Bill's on call. Two more votes.
Thank you, Mr. Chair. Thank you, members.
Thank you. Mr. Hill.